All right, good morning, everybody. Welcome back. And we're going to continue our deposition training. I want you to know that you are more than welcome to jump in at any time. We have some experienced attorneys here that will be very helpful. I'm sure they have a lot of questions. They may even disagree with me on some of the things because a lot of it has to do with technique, and technique is going to be personal. It's going to matter what kind of person you are, how you're perceived by other people, and that's going to be what defines how you're going to behave at a deposition, because there's no single uniform way. If you're basically a good person, a nice person, and you have respect for people, you're going to have a nice, easy deposition. Usually, okay. You know how to deal with people. You don't you don't have any tells to show them that you don't believe what they're saying, and you are not in the habit of discounting their emotions about it. You have to remember that people that you're deposing, they're not always this is not their this is not what they're used to doing. They're in an environment that is very stressful for them, and they could be acting out of character. Okay, so part of your job is going to be to put them at ease. Okay, and we'll get more to that later. So we're not going to be talking about specific types of deposition yet. That's going to come later on. We're going to break it down. So everything we're talking about now is going to be general, all right? And we're going to assume that we have non-lawyers, that we have legal assistants that are present, and we're going to assume that we have people that have not done depositions or even seen depositions before, okay? So this is the second installment in our series. So the first one, we gave a very, very general introduction for about 1 hour about what to expect and what to do at a deposition. We still have a lot of things to get into, specifically with the ground rules and with the language that's used, so you get used to it. We talked about things like the court reporter and the dog sheets and what those things are. And if you remember, the dog sheets are the sheets that the court reporter fills out with basic information of who is there, what the case is, the case number, case name, and things like that. And that becomes important, as we talked about, if you have to do a reconstruction. For example, if the deposition is lost forever and it's, years have gone by, and you're reconstructing, who was there, you're trying to find out who was there, what the subject was, what the exhibits were, to help you put everything back together. So you call up your court reporter and you say, hey, do you have the dog sheet for that day? So that's a good thing to keep in mind. So now you haven't done a deposition. Now let's say the people that you're there with, they haven't done too many depositions. They're inexperienced too. So who goes first? Who is going to, you have a bunch of people. It's not just you and the opposing counsel. You have like 3 other defense attorneys there. And you have on the caption, it's not just the party A versus party B, but it's party A versus party B, party C, party D. And the plaintiff, party A, is being deposed. So who gets to ask the questions first? And the answer is very simple. It goes in the order of the caption. So if you represent party B, you get to ask questions first. If you represent party C, then you go second, and on and on. Now, let's say you have 3 defense counsel there, and it's the plaintiff's deposition, and counsel for party B doesn't feel like asking questions for that day, and you represent party C, and they say, hey, you feel like doing it today? I'm feeling like a little under the weather, whatever. My answer to you is yes, jump at it. You should always want to be the one in charge of the deposition. It's not going to change anything. It's just going to give you the opportunity to control the questions and how everything is done. I mean, who knows? Party B, they may not even know how to conduct a deposition, and they're going to ask questions that make no difference to you in your case, and you're going to have to start all over anyway. So now that you have training, you should be the one that takes control and does a deposition. Have I heard situations where the attorneys for party C say, oh no, you got to go, you're first in line in the caption? Absolutely. There are some attorneys that all they do are depositions. That's what they do every single day. Some of them do 2 in 1 day, and they just get tired of it. They just don't want to do it. But I'm telling you, and especially if you're from this firm, should want to be the one in control of the deposition. And just keep in mind that it goes in order of the caption. a couple of things a couple of ground rules with respect to objections. We talked a little bit about objections. And, we talked about, whether you should object and whether you shouldn't object, to certain questions and what you should say when you get answers that are inappropriate. And I told you one of the most important objections is when the witness gives an answer that is not responsive to your question and throws in all this extra information that you didn't need. You must remember to move to strike and object to the parts of the question that are not responsive. Okay, it's very important because what you see more often than I guarantee you're going to see this, is instead of objecting, the attorney who's asking the question will say, well, we really appreciate that answer that you gave us, but that's not what I'm asking. That's not an objection. It is an objection sorts, but it's not a legal objection. And that objection is not going to be preserved. So giving a snide, nasty response to that non-responsive answer you got is not going to be enough. You can say, objection, move to strike is not responsive, and then give them the dirty look if you really have to. I don't see any purpose in it. Showing annoyance is not, in my opinion, in that situation, is not a lawyerly thing to do. You gain nothing from it, all right? And it also presents an opportunity for you to drive a wedge between the witness and their own attorney. And I know this sounds like a dirty trick, and it's not meant to. It's not a dirty trick, but it helps psychologically. So, and what I mean by that is this. After they give the non-responsive answer and you move to strike, the answer is not responsive, you could say to your opposing counsel there or the defending counsel, like, could you please direct your client to just answer my question? And more often than not, they do. And now you have the attorney for the other side, reprimanding their own client to answer the question. Now, what happens if the attorney who's asking questions and you're defending does that to you? Your reaction should not be to direct your own witness, your own client, to answer the question. Just tell the attorney, please continue with your questioning, politely. All right, you don't want to do that to your own client. They got the message. They don't have to have their attorney repeat it. Okay, so and you may want to, and we're going to have a whole hour dedicated to prepping your client for the deposition on another day, but that's something that's important for right now. You'll hear attorneys, even experienced ones, they'll begin a question and it's a false start. All that comes out of their mouths is garbled syntax, and they'll look at the court report and they'll say, strike that. I mean, that's something that our litigators here should get out of their parlance right from the get-go. All right. You hear attorneys say strike that who are non-litigators, like in the middle of a conversation at a party or something, they'll be talking about something and then decide they want to change the phraseology, and they'll say, well, strike that. It sounds very lawyerly, they think, it doesn't. Okay, real litigators really don't say strike that, because at trial, if you're asking a question of a witness and you get mixed up in your question, in your phraseology, or your phrasing rather, you don't say to the judge, strike that. You don't say to the court reporter, strike that. You just say this, withdrawn, and start all over. If you say strike that at trial, the judge 9 times out of 10 will admonish you, because you do not have the power to strike anything in court unless you move the court to strike it. You understand? So an attorney saying strike that, it just doesn't make any sense. And we get what you mean at the deposition when you say strike that, but it's a bad habit. So if you can't do it at trial, you should not do it at the deposition. Stay away from that. You just say withdrawn and start all over. And it doesn't matter how many times. If you're not getting it right, even if it's 3-4 times, withdraw and start again. Okay, and ask your question so you have a clear question that's understood by the witness so that they can answer, so you have a nice clean transcript. Okay, other than getting this really boggled question, this phrasing that makes absolutely no sense. You'll be trying for hours trying to figure out what was meant in that. It'll be a useless transcript for you at that point, at least a useless part of the transcript. So let's say you're defending the deposition and the attorney asks a question that it's very confusing, clearly vague, an improper question. What you do is you object. You say objection or objection to form. That's okay. You can even say objection confusing. The better objection at a deposition is to say objection to form. All right, that is what you do at a deposition. At a trial, and forgive me for those who are not going to go to trial on this, but an objection to form, saying that objection to form at trial is not proper. That is not a proper objection to make. And what do you mean when we say objection to form? I'm going to get to that in 1 second. So if you don't like the form of the question, you object to the form, does that mean that the witness does not answer? Does that mean your client now does, because they're going to look at you? And does that mean that you say, okay, you don't have to answer that question? The answer is no. And we talked about that in the first installment. We said we don't have the authority unless it's very, very specific situation having to do with privilege or something that's just really meant to harass the person and has no value to the case at all. So here's how it works. The question is asked, the objection is made, objection to form, and then you say, you direct your client, you say, you can answer over the objection, right? So questions asked, objection to form, you can answer over the objection. That's all you say, all right? You don't say you can answer over the objection if you know, because we talked about that being, as nudging, which is improper, and you will not let your opposing attorney do that at any time if you know. And I have something in the handouts that gives a specific excerpt of a deposition where they did nudge their client, and there was sanction. You don't want to be on the other end of sanctions. All right, so all right, I know it's a little bit confusing about the objection to form, and we're going to talk about what we mean when we say objection to form. And just one other thing before I get into that, we talked about substantive objections such as hearsay, right? You don't have to make that objection, all right, because that's a substantive objection. And the reason you don't have to is because that's preserved for trial. You can make that during the course of the trial. You can make that objection. All right. If you don't make the form objection during the deposition, then it's gone forever. And they can use that testimony on cross-examination to hurt you. Okay. So it's very important. So what do we mean by the form objections? And the best way to do this is to use a mnemonic. And I'm going to spell it out for you. It's Marvelax. It's MARVILACS. All right, and each of those letters stands for something. So the M stands for multiple. What color was the light and what time was it? All right, that's more than one question. So if they ask what color was the light and what time was it, you object to the form and you direct your client that they can answer over the objection. All right, that's the M in Marvelax. The A stands for ambiguous, where the answer to the question could have two opposing answers to it. All right. Again, objection to form, you can answer over the objection. The R in Marvelax stands for repetitive. All right. I have in the materials like the phraseology asked and answered. People will know what you mean by that. Even judges will know what you mean by an asked and answered objection. All right. But the better objection would be repetitive. Okay, because repetitive is actually in the statutes. You can see that word is there. Asked and answered isn't anywhere. All right. So if that question was asked of your client already and they're asking it again, and asking it a third time, you object to form. You can answer over my objection. Okay? And now we're moving to the V in Marvelax, which is vague. all right, which is a close cousin to confusing or a close cousin to ambiguous. You're not sure exactly what you're talking about. The improper objection is objection. I don't know what you're talking about. That is not a legal objection. All right. Objection to form. You can answer over my objection. Then we get to the I, which is irrelevant. And we talked about irrelevant not being a proper objection most of the time, but it can be. And I gave an example where the guy is asked during his testimony about his sexual activity. It was irrelevant. It was asked of him just to embarrass him in that situation. So it was palpably improper. It was irrelevant. Objection, irrelevant. Okay. The L in Marvel Acts is leading. All right. And we all know what leading is. We talked about that last time. The light was red when he came to the intersection, right? It was raining that day, right? Those are leading questions. Objection to form, you can answer over my objection. Next, we get to A, which I have for assumes facts not in evidence. All right, what does that mean? Exactly. It sounds very technical. It's not. You're asking a question about something that has not been introduced. There's been no foundation at all about this. So who were you talking to? What did the passenger in the car say to you when you approached the intersection? Now, there's been no questioning about whether there was even a person in the car at the time of the accident. So that question has an assumption that is built into it that is not part of the record. No one even said there was a passenger in the car, and you're asking about what did the passenger say. So it assumes a fact, not an evidence. How do you respond? Objection, you can answer over. Objection to form, you can answer over the objection. Okay. Next, we get to C for calls for a legal conclusion. Was that a violation of the vehicle and traffic law when you went through the red light at the intersection? That's really, it's a couple of objections. It may assume a fact not in evidence, but it's definitely calling for a legal conclusion. And you're not allowed to ask questions that call for a legal conclusion most of the time of a witness who is not an attorney. And even if an attorney is a witness who you're questioning, you may not be permitted to ask a question that calls for a legal conclusion. So that's the C conclusion. Now the C objection, and then finally we get to S, which is for speculative. You're actually asking the witness to guess at something. That is okay to ask at a deposition. And again, it's objection is to form. You can answer over my objection. You are allowed to ask the witness to speculate, and you can even tell them speculate. Objection to form. You can answer over my objection. It's not a problem. Okay. So those are the Marvel Acts form objections. There are others. There are different ways of phrasing them. But basically, if you have the Marvel Acts form objections, you're going to be good. And if you just memorize those and you object when those types of questions pop up, then you'll be okay, and your record will be properly protected. And that's what it's all about. All right, and you do have to memorize it. It just comes and you won't. Eventually, you're not going to need the mnemonic to remember. You'll just know them all, and you'll recognize them with practice. And a good way to practice is by reading depo transcripts and seeing for yourself. And you'll notice when you're reading the transcripts that the attorneys don't object a lot of times when they should have. And that's why it's good practice, because you go through it and you figure out why you would object in that situation. Now, maybe the attorney in the deposition transcript, maybe they decided not to object, and that should be done. Any objection that you have, you have to determine what are the metrics. What do you gain? What do you lose? Or do you just break even on the objection? If you're what I mean by lose, is it just wasting time? Is the answer to this question really gonna harm your case? I mean, do you really want to just show the opposing counsel that you know what an objection, what a proper objection is? If that is, then by all means make your objection. You won't be wrong. If the form is defective and you make the objection, no one's going to ever fault you for it. But I prefer that our attorneys use them sparingly and only when it has passed through the metrics examination, that we have gained something, that we didn't lose something by making the objection, even if that is just time. So you do in the beginning, when you're going through your analyses of the deposition transcripts, then by all means, object to everything, you know, and understand why. And you do that and you practice it and you go over and over. And, you know, I'm telling you, in the practice of law, in our profession, there are two teachers. One is a boring teacher and one is a cruel teacher. The boring teacher is repetition, just doing it over and over and over, and you will learn. The cruel teacher is failure, all right? You don't want to fail. You don't want to have a situation where you did not object to the form, and a year and a half later, you're at trial, and somebody's waiving that deposition transcript and using a question to impeach your client when they would not have been able to do that if you had objected properly. You don't want failure to be your teacher in that situation. It's much better to have the repetition. Boring as it may be, if you're a musician, you know, doing your scales, it's not the most fun thing, but you know what? The results will be very positive for you. So those are the metrics of that's when you consider the metrics of making the objection. That comes, you know, over time you're going to decide what it is to do. So we talked about the Marvel Acts form objections and the multiple. A, ambiguous, R, repetitive, B, vague, I, irrelevant, L, leading, A, assumes facts not in evidence, C, calls for a conclusion, and S, speculative. That's your knowledge set for form objections. Anything else is reserved for trial. All right. A couple of other things we're talking about proper terminology usage at the deposition itself. You don't want to alienate your witness that you're speaking to, that you're asking questions of, by using any legalese. All right, so you have to, you know, you may want to, and maybe you shortcut, and maybe because you're used to using things all the time. You don't want to lose them at the get-go. Anyway, some of the terminology that you're going to hear, you haven't done a deposition before. You have properly provided copies of the exhibits that you're going to be using during your examination. You've given a copy to the court reporter. You came early and you pre-marked everything. You said this is going to be, you're the defendant, so your letters on the stickers are going to be A, B, C, D. If you're the plaintiff, they're going to be 1, 2, 3, 4. Remember we talked about that? But this was all done before, because the court reporters usually come early, and you have 3 documents or you have 30 documents that you're going to use. You can say, just I'm the defendant, so let's just mark this as defendants A, defendants B, defendants C. And so that's ready. It's in the hopper. The copies are ready to be handed out to opposing counsel when they finally show up. You have a copy for yourself and you have a copy for the witness. I know it sounds like a lot of copies, but it's just do it that way, okay? It's when it's professional, it gets things moving along. Your opposing counsel knows that you know what you're doing and that you've done this before. Okay, so you're all set up, all right? And this is on your first deposition, okay? You haven't even done one, or you haven't even seen one before. So the court reporter has everything, and she says to you, or he says to you, usual steps, and you're like, oh my God, what do you mean by usual steps? The usual steps are contained in the front of every deposition transcript. It's from the Uniform Court Rules. And it, in a nutshell, it is that all objections, except to those of form, are reserved for trial, right? Those are the usual steps, all right? At least the important part of it. That's the important part. And I don't know what the purpose of saying usual steps is, because the court rules are the court rules and the law is the law. You don't have to agree that the law is the law unless you're changing something. litigants are permitted to chart the course of their own litigation. You can decide by stipulation, by agreement, and that's what a stip is. It's just an agreement, a written agreement by the attorneys to say, you know what, all leading questions are admissible, and there's going to be no objections, and we're not going to object at the time of trial. I don't know why you would want to do that. Maybe so you don't have all the objections going on. They have no intentions of going to trial, and they just want to use this transcript. You can agree to that. So, and that stipulation would be made part of the record, all right? And this is a very rare thing, but it can be done. And in that situation, I would understand why you would put the stipulations on the record, okay? And we're going to get to the on the record phraseology as well, just in a minute. All right, so now you know what the court reporter means when they say usual steps. You say yeah. And then the next question they're going to ask you is whether it's pursuant to court order. And you're like, wow, I don't remember there being a court order saying that we're supposed to be doing the depositions. Well, you know what? Because you didn't think about it enough and they caught you off guard when they asked you that question. But in state court, you have a preliminary conference order that sets the deposition. So that's it in state court. And you're also going to have a scheduling order in federal court. So the answer to that question is almost always going to be pursuant to court order. But let's just say, why do they ask that question? Is there an alternative? Yes, there is. Let's say you didn't have a preliminary conference, or you didn't have a scheduling order, and you're at the deposition stage somehow. Then it's going to be it's not going to be conducted pursuant to court order. It's going to be pursuant to stipulation. All right, and I think that they believe that that's important. It could be important, but it doesn't change the nature of the deposition at all. And one of the touchstones, one of the things to remember always in the conduct of a deposition, whether you're in federal court or state court, the deposition is conducted in the same manner as a court proceeding, as if you were in court. Okay, and that's in 3113 of the CPLR, and it's in Article 30. It's not article. It's Federal Rule of Civil Procedure 30 C1. Okay, and it specifically says it shall be conducted in the same manner as a trial. And it's really important to remember that particular language, because if opposing counsel starts misbehaving and they start doing things that they definitely would not do in court in front of a judge, you can remind them of what 3113 says. I did say 3113 last, right? Like if I said 4113, I mean. But anyway, it's 3113 and 30B1 of the Federal Rules of Civil Procedure. You certainly wouldn't do this in front of an Article 3 judge. You certainly wouldn't do this in front of a justice of the Supreme Court of the state of New York. So you're not going to do it here. And if you do, you're going to get sanctioned. I'm going to make the motion. They don't have to be nasty like that, but that should be the thought process in your head. And if you need it, you take it out. So it's really important. And now that I mentioned 134513, which is what we talked about last time in the introduction of criminal history, specifically with convictions. And under the federal 609, I was going over in my head, and I have a recollection of saying 603, which I'm sorry, I didn't mean 603. If I did say it, it's 609. Okay, those are also two very important statutes to remember when you're asking questions at the time about criminal convictions, because it's a nasty topic. It's embarrassing to the witness. But it has to be asked. You have to ask the question. No matter how innocent. I mean, look, use your judgment. Okay, if you use your judgment, but you'd be surprised. You'd really be surprised. These are human beings, and human beings make mistakes, and people change, and the person in front of you may be changed. But you know what? That information about their convictions could be very helpful to you at trial. Okay, so that's where we are with back to whether this is pursuant to STIP or pursuant to court order. Okay, so those are two questions that I saved you from being embarrassed when you're doing your first deposition. Okay, remember? Remember, this is pursuant to court order, and there's usual steps, and this is pursuant to. They usually ask it like that, leaving it for you to fill in the blanks, and you just say court order. All right, so that I feel much better that I told you about that, because we didn't talk about that last time, and I would have sent you to your first deposition, and you would have been like, oh, Joe didn't tell us about that, but now I did, so my conscience is clear. I'll be much better now. All right, you learned about the Marvel Act's leading objections, okay, and that's just practicing, going over these things. We talked about those things. We're going to memorize that mnemonic so that we never forget. And we're going to review transcripts so that we understand, and so we can practice and understand when these objections come into play. And you'll have the luxury during your reviews of these of the deposition transcripts, you'll be able to do the metrics there and think about what was the attorney thinking, when he did not object, or did she not object there because they needed that information? Maybe they did. Who knows? But at least you will know. We will not be using the strike that ever. I promise you, you're going to hear it a million times, and you'll chuckle to yourself, not out loud. You'll definitely chuckle to yourself about that when you hear that, and when you're at a cocktail party. Well, they don't really have cocktail parties anymore. But when you're at the bar or something, and you hear some attorney saying strike that in the middle of this conversation about a football game, again, that'll be another internal chuckle. So before we get on to our next topic, are there any reactions, any questions, any anecdotes that anybody would like to share?
Joe, sorry, go ahead, Israel.
No, you beat me. Go ahead, Greg.
Joe, can you describe usual steps in pursuant to order with regards to a non-party witness deposition or for a trial deposition?
Oh yeah, that's a really good question. The non-party deposition, Greg, and we're going to get into that specifically because I believe that that's a whole different animal. And depending on what the perspective is, whether you're representing that non-party witness or whether you're questioning the non-party witness, and also you get a whole bunch of other problems that come in. But as far as how the usual steps would apply there, it definitely would. The same way, it would be treated the same way. That particular transcript, by the way, because all parties have had an opportunity to question and cross-examine, that would be admissible on its own. So you wouldn't need that person to come in and testify. That transcript could actually come in and just be read to the jury or to the judge, all by itself. Unlike parties, like I cannot put my client's testimony, transcript into evidence if they're there to testify. That would be improper bolstering, and it's just not permitted. However, you can put in an adverse party, that was the whole thing. But with the non-party, as long as all parties had the opportunity to question and cross-examine, then that deposition transcript comes in at trial. So that raises a whole bunch of other questions too about whether you want that videotaped and the types of questioning that you would ask that individual. Like, it's okay to ask why of an opposing witness, which you would never ever do on cross-examination, and we talked about that. So, I mean, that is really in 99% of the times asking an open-ended question like why is the third rail to a textbook cross-examination. You already know the answers, and you're making them give affirmative responses to the testimony that you're actually speaking into the record. But at a deposition, you can ask them why. It's if you, for some reason, need the answer to a question like why, like why were you drinking on the day of the accident? Why would you want to know that? Why would that be important to you? But sometimes it is. But back to the non-party, because their transcript is going to be admissible at trial, you don't want to ask questions like that about why, because you don't know the answer to it, and if it's bad, it's coming in anyway. So And so you do have to be careful of what kind of questions that you ask there. But back to your initial question, I'm sorry, I went off a little bit, but as far as like, is this pursuant to? This would be pursuant to, and I should have added this on, this would be pursuant to subpoena, most likely. And the subpoena would actually be made part of the record. So with Greg's question, I'm going to change my instructions for pursuant to court order, or pursuant to stipulation, or pursuant to subpoena. So that's with the non-party. It would be an actual subpoena. Does that answer the question, Greg?
Better than I ever could have imagined.
Awesome, man. That makes me happy. Israel, you had a question.
Yeah, first a comment. I actually heard of a case where the court reporter said usual steps and OC actually said no. And the attorney didn't know what to do.
That's what I mean. So, I mean, the real question is, and I get that, like, what do you do? But like, it's like, okay, you don't stip, so who cares?
Yeah. In that case, actually, the attorney called the judge on the phone and said OC said no, and the judge admonished the attorney and said usual steps apply, proceed. So if it ever happens, so, no one should like get nervous about that.
Exactly. I think that makes the point on all fours. I mean, of course they apply whether you stip or not, and it's just one of the niceties. Excuse me. It's just one of the niceties that have lasted the test of time. That is there. Usual steps. I mean, that's like one of the first things. And the court report, if you looked at the court reporter like as if you were confused, they would honestly believe that they had a long day in front of them. So I think it's just a matter of putting everybody at ease. Usual, just the usual steps, unless you have something specific, unless like for example, like something that wouldn't be a usual step would be that the parties agree that the deposition testimony will be used at trial, waiving all objections. So that would be an unusual provision to the stip. So in that case, so if you were writing up that stip, you wouldn't rewrite, the court rules and everything. You would just add that provision. So it would be the usual steps plus this stipulation, that you both agree that the stip can just be read into evidence. And a situation where you would use that is if you had an elderly party or a witness or somebody who lived, outside of the country or more than 100 miles away from the place where the trial is going to be. This way there's no, misunderstanding about the usage of that particular transcript, and it's going to speed up the whole process for your joint pretrial order or for your trial prep in state court. Does that answer you okay, Israel?
Yes, thanks so much. And I had a question on the objection for calls for legal conclusion. Can you direct the witness not to answer that?
The answer is you don't have the authority to direct a witness to not answer the question. How I would handle it is this way. Objection that calls for a legal conclusion, that is an illegal question, and I'm going to direct my client to not answer that question. And maybe we need a ruling on this to see if the judge will agree that you're allowed to ask a question that calls for a legal conclusion. That's how I would handle that. I've never had to do that before, but if the attorney was insistent, that's how I would handle that objection. I don't recommend directing a witness to not answer a question, especially to new attorneys, because you don't want to get into bad habits. You don't want to risk getting in trouble. But if the question is so harmful, if you've done the metrics on this and it seems like you have a lot to lose on that, then it takes drastic measures, and you're going to have to say, listen, If you insist on asking that, I'm not going to direct my client to not answer because I understand that that is against the court rules and could subject both of us to sanctions. But I'm going to terminate the examination. I'm going to terminate the deposition right now, and I'm going to be filing a motion for a protective order. And pending the determination of my motion, then we'll continue the deposition and see how they would take it from there. Excuse me. That's the proper way. That's the proper way to handle it. You know, Israel, if you have only good attorneys at the deposition, it's going to be an easy one. It's going to be a productive day. It's going to be a fruitful transcript for everybody. There's going to be no objections on it because the attorneys know how to ask questions. There's going to be no colloquy because the attorneys know that colloquy is not allowed in discussions on the law and things of that nature are not permitted. And it's going to be pretty pleasant. So it's when you get, and you know what, it's going to happen. You're not going to always have good adversaries or knowledgeable adversaries is what I mean. And so you have to be the one to instruct and help them and guide them and prevent them from getting Rule 130 sanctions or Federal Civil Procedure 37 sanctions. You know, if I have to make a motion under Rule 37 to get a response to one of my questions and I'm successful on that, I'm entitled to attorney's fees. And it's mandatory in federal court. And I'm going to get those attorney's fees for the client. I have a duty to do that, you know? So I hope that answers your question. Anybody else? And
Thanks,
I'm sorry, go ahead.
Just one more question.
Yeah,
Sorry.
of course. No, as many as you like.
On the speculation objection. So a lot of times you'll get like, you know, when did this happen? And witness will say, I don't remember. And then they'll say, well, you know, was it less than 5 years? Would that fall under speculation or would that not apply because they're quantifying that more?
No, they're not, because they're not guessing as to when this happened, but what you're doing is you're starting to close the window of time. So your temporal reduction, your attempted temporal reduction is not calling for speculation. It's just waking up their memory, because I mean if they're really difficult and you know the accident happened 2 years ago, you know, and you get them to say would it have been within the past 5 years, and they say I don't know. Then you say, well, would you say within the past 10 years? Would that be fair? I really can't remember. Well, how about 20 years? Nah, I can't say for sure. Well, how about 30 years? And you go on, and now you have, you know, you have a transcript that has this guy doesn't remember, you know, he's 40 years old and you can't remember if it happened 50 years ago. So you have, you know, that's really great stuff, man. You know, I mean, I think they're being wise guys, but, you know, you have some really good testimony there to impeach them on, or even to show that they're, you know, that they're just, you know, they're not being forthcoming with what their knowledge of the facts are. And that's why it's important, you know, when you know you have a difficult client, like that's going to be evasive, you're really going to ask a lot more questions than you normally would. And you're going to ask, you know, I used to laugh when I first began, when, you know, you'd hear like some of these really experienced attorneys and they're questioning a difficult client, and they're asking things like what they ate for breakfast that day, you know, it was a muffin, what kind of muffin was it? And these are actual questions that I have specific recollection of. I was like, why are they asking about these details? And the guys would be telling them they had a blueberry muffin and they had a coffee with milk, no sugar. And there was some guy sitting next to them there and they were talking about that. And then they don't remember if they were in an accident that day. You know, it's really, that's why you kind of get a feel for, you know, what you have to do to lay the foundation for dealing with an invasive witness. Because you have all this beautiful information, this memory palace that you've created with your questioning of them, and you know, one of the windows in the palace is broken, and unfortunately for the witness, that's the one that really matters, because that's where all the information that you really need to see is not. They're not letting you in on that, and it'll be the fact finder is going to pick up on that very easily. So that's why you develop all these questions. And we're going to talk about expanding how to expand questions so that and this will be helpful to to the legal staff, and when they're dealing with intakes, and when you're by developing background and just having more than yes no responses, and when somebody says I don't remember, there's definitely a matrix that should pop up like Terminator, like how you should, questions that you should ask when they say they don't remember. I mean, look, some people don't remember, and they're not being evasive, they just have a bad memory, whatever it is. That's when that's when your matrix pops up and you ask questions like, is there anything that would refresh your memory? Is there any document that you could look at that would refresh your memory as to what happened today? Is there any picture that exists, any photograph that exists that would help refresh your memory, even a little bit as to one detail? Is there anybody that you spoke to about the accident at that time, or spoke to about this event at that time, that could help, that if I spoke to them, they would maybe give me something to help you remember this, all these questions should pop up. If they say, no, I don't remember, it's not going to look too good for them. So it's going to be very, very helpful. And at the end of your questioning, you're going to say, there's nothing that exists from the time that this event happened up until today that would refresh your memory. And there's nothing from today up until the time that you have to testify trial, because this case is going to trial, that you will say, oh, I looked at this and now my memory is refreshed. There's nothing that could possibly exist. Is that what you're telling me now? And if they say yes, and they come to trial and all of a sudden they have this like epiphany of knowledge about the event, you got them. And you could spend a lot of time, making your point about them lying about that. And you know how it is at trial. You lie at one thing, it can be presumed by the jury that they lie, or the fact finder that they lie in everything else. So the witness who just can't remember, if they're being malicious, you have tools. You have tools in your pocket that you can use to make their tactic unuseful for them, right? And so that's what it's really all about. Don't be afraid of the witness who cannot remember. You should enjoy that and develop everything else that they have a memory of, and get as close as you can to the time of the act about things of what they did. If they say they can't remember anything at all, that's not going to be helpful for them. And the same goes for the witness that is just giving yes or no responses. That's something that, attorneys, they prep their clients to say yes or no. If you can't answer yes or no, or, if you can't keep it within 3 words, then you're going to be in trouble, and you'll be able to detect who those witnesses are, because every once in a while they'll say yes, but this is what happened, and they'll cut themselves off because they've been trained to not provide anymore. And that's when you have to pick up on that thread and continue on and say, you were saying that you were saying, but this, what were you going to say about that? You can, there's no doubt about it. You can pick up on anything that they say and use it as a thread to pull it to get to the story that you want. That's why you have to really, our most important skill is not coming up with, killer scalpel-like questions. That's not, it's listening. And one of the mistakes that young attorneys make, and when I say young, I mean young in experience with depositions, is that they have their lists of questions or even just their matrix, and they ask a question and they're not paying attention to what the witness is saying. They're looking at their next question, or just a bright idea came and now they're going to shift their strategy. And they don't hear what was said. And you could be missing out on a beautiful thread that you can pull on and bring you to a whole other line of questioning. Like they mentioned somebody else was there. Oh, well, who was that person? And what is their contact information? And how long did you know them for? What did they do for a living? Have you spoken to them since the time of the accident? Have you spoken to them between do you have any intentions of meeting this person between now and the time of trial, or in the future, or whatever? but you missed out on that. You missed out on a good 20 questions and maybe the resolution to your case because you were too busy looking at your next question. So that's why you have to look them in the eye, not because you're trying to see into their soul. I don't mean it like that. I mean really paying attention to what they're saying. That's what your real skill is. That's when you're going to capture all these great things and do your client justice and I mean justice in your performance by paying attention to these little things and taking advantage of them. So that's I know I veered off a little bit, but I hope that answered your question.
Joe, maybe that's why you should never have your questions like numbered. This is question number 1. So you should have write an outline of your topics and subtopics and maybe a few questions. But that's how I was taught. Never put in your full questions because that's the thing that's going to happen. You're just going to focus on your questions and not on the answer.
I think I think you were taught entirely correctly, Carla, and I agree with you 100%. And it's bad practice to come with your with your scripted questions and read off the questions because you, as Carla pointed out, you will fall into the trap of not listening and going on to your next question. The perfect deposition, or it can never be perfect, but the best deposition, the most fruitful ones, are where you're really interested in what the witness has to say, and you're really engaging them in a conversation, and you're not trying to speak to them from a loftier plane by using strange legalese. Why would you do that? You are talking to a human being and you're trying to get the information from them so that you can make a determination as to what your case is about. And you want them to, you drive a wedge between them and their attorney and make the attorney direct them to answer only the questions. You're paying attention to them. You're listening to them. You're showing respect to them. You're in a really good place to get some good stuff. You're really in a good place. And you're not going to do that by going through a binder of questions as you go page by page. Your testimony is going to be artificial. Your conversation with them is going to be artificial. They're going to know that you're following a script, and they're just going to be like, they might as well just fill out a questionnaire. Is that okay, Carla? Was that so? I agree with you 100%.
Yes.
And how you were taught was, that's I was also taught that way, and I think
my professor always said that Santa Claus does not exist. So don't ask a question expecting your answer.
That's a little cynical, but but I think that's really good advice, and you had a good teacher, man. That's awesome. Which reminds me, we were talking about the conduct of the deposition being in the same manner as the trial, and we talked about under the federal rules 30 and subsection 1. Subsection C 30C1. If you go down a couple of lines to 30C3, there's a really interesting little device there that I've actually used only once before. But what subsection 3 allows you to do is that you get notice for a deposition. This is a federal court only. And you know what? You don't really feel that you want to be at this particular deposition for some reason, or your client doesn't feel that it's necessary and doesn't want you to go to that deposition. Under C3, you are allowed to submit questions that you want asked of the witness. All right. So you have your caption and you have your notice to pursuant to 30 C3 to have questions asked of the witness, and you can write down the questions that you want asked. And what happens is you serve that on the noticing party. Say it's only one question. And the question is, were you ever convicted of a crime? And then maybe bracket out if the answer is yes, when, where, details. You submit that to the noticing party. The noticing party must give that to the court reporter. So I'd find out who the court reporter was and give them a copy anyway, so that they know. And then the court reporter at some point during the deposition asks your questions. How awesome is that? I'm just, it's better than doing absolutely nothing. And if you have a difficult client who doesn't want to spend any money and feels that it's worth it, at least you'll have done something to protect the record, maybe get yourself some good information. Because look, even though it's federal court, you may have an attorney who doesn't want to ask whether you were convicted of a crime, and then you're lost, and it's too late. What are you going to do? So a little. I still have some things that I can share with you guys, and I don't know. I'm not sure if Carla's professor knew, probably did, but I actually used it once, and it was very helpful, and people were impressed that the attorney who I served on didn't he called me and said he didn't know what to do with it, and I had to just read him the statute and explain to him. It was done. I got my transcript, and it was pretty magical. So we went over a lot of things today. We're still just scratching the surface. I'm going to answer questions. I'm not going just yet. We have a lot of things to cover, and as we go through each installment here, you'll feel a little bit better, a little bit more empowered. It won't be so. The purpose of this is to demystify the deposition process so everybody understands it. I wanted to today, but I'm not able to. I wasn't able to. I'm going to get more into it now about developing questions so that the one question that you get a yes or no answer to, you can bracket that so it goes into many more questions so you can get background information to have a better deposition and to have a better intake, or to, for example, if you're doing a pre-sentence report by defense counsel, this is going to be so helpful to you. And you can use these exact techniques when you're questioning our client to get an excellent and detailed pre-sentence report. So at this point, I'll take questions, and we'll continue the lecture next week. Any questions? Any comments?
I love the beginning, Joe. I caught only the beginning because I had a couple of intakes. But real quick, you mentioned something that you can say strike.
Yes.
Okay. What if they do say strike? Can you respond to that, or how does that work?
Yeah, the response is just an internal giggle and a little bit of an arrogant, like nod to yourself. But that's really it. And you're going to hear it. You're going to hear it all the time through your career. And I'm just asking you not to judge anybody on it. I'm just saying that it's improper. You just say withdrawn and start your question all over. Like it's such a big deal. You made a mistake, and yet instead of this beautiful, perfect question, it came out as garbled syntax and nobody knows what the hell you're talking about. Like it's such a big deal to say withdrawn and start all over. No, you have to make this like, you're in control, I'm important, strike that. So you're bossing around the court report and letting everybody know that you have the power to strike, which you don't. And the reason why I don't want our attorneys doing, because I don't want them to get into the habit of saying strike that, because they'll know what you're talking about. And they will understand that you're starting over again. But I just don't want our attorneys saying strike that in court, because we've seen that happen and it's not pretty. You don't want to anger the judge, because only the judge has the power to strike, to order the court reporter to strike testimony from the record. The most that an attorney can do is ask the court in this form, Your Honor, I move to strike the answers to the question that are not responsive. And I ask for a jury instruction so they understand to disregard the question, and I ask counsel to be admonished. Something like that.
Real quick, will we ever, or does anybody get to sit on a deposition, or do they have to get, permission from the client? Or
No, I want everybody to have sat on a deposition at least once. And I say not more than once, because, unless you have one of our cool attorneys doing the questioning, they're very boring. And you'll want to get the hell out of there. But yes, there should be an opportunity, and you should arrange that. Not all attorneys like having audiences. I do. As many people that want to come to a deposition at a given time is okay with me. If you're bringing them physically to the place, it's appropriate to just inform opposing counsel. You don't have to. You don't have to, just let them know you're bringing, you're either your paralegal or, a law student, law clerk, or an associate. And you tell the court reporter that you have, your associate here, and to give them what's called an also present. So that on the transcript itself will say Joseph Nohavicka for the plaintiff, Israel Klein for the defendant, also present, Tasso Pardalis.
Okay.
This way, because again, and she writes that down on her dog sheet, if you remember I said that. So if you have to do a reconstruction and you're trying to find out who may have the transcript, they have everybody's names there. So that, who knows? Maybe one person is still alive. It's terrible to say. I don't mean to be flip about it, but I've seen it happen where they were looking to reconstruct the deposition that happened 20 years ago. And they would find like somebody who was around who was also there and had no involvement, but they were able to lead them to where a copy of the transcript would be. So, and I'm sorry that you missed the rest of it, Stace. But
you are going to send notes, correct?
Isos, perhaps.
Isos, perhaps. Okay.
Jack leading.
Sustained. Stacy's sanctioned.
Oh my gosh.
Yeah, of course.
All right. Sounds good.
All right. And if
I
there's
really
nothing else,
I really enjoyed it today. Sorry.
I'm really happy. So we'll adjourn until next week. Okay. Thanks for your attention, and everybody who participated. Thank you so much, and I'll talk to you guys later.